Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. I think it's fair to say that one of the hot button issues in America right now is the issue of abortion. I personally am pro-life. Today we're going to talk about one of the abortion pills and a Supreme Court case dealing with it. Now, what's interesting about that, everybody knows that abortion is a very hot button topic right now. Everybody has different views on it. The key thing here is that this is not an on the merits decision. In other words, nobody on the court had to take a moral position on whether abortion was good or bad in order to decide this case because of the way that Supreme Courts, both at the state level and the Supreme Court of the United States, decide cases. The first thing that a court has to do before it can address a case, whether it's a district court, a court of appeals, or the Supreme Court, is determine whether it has jurisdiction. And one of the fundamental tenets of jurisdiction is standing. And as a result of that, this case was decided pretty much the day it was filed because of the issue of standing. So let's take a look at the actual text of the case. This is the Food and Drug Administration versus the Alliance for Hippocratic Medicine. So in 2000, the Food and Drug Administration approved a new drug application for mifepristone tablets marketed under the brand name Mifeprex for use in terminating pregnancies up to 7 weeks. As additional information came in, they relaxed some of the restrictions and allowed it to terminate pregnancies up to 10 weeks. They usually required an in-person visit, and in 2021, the FDA announced that it was no longer enforce the initial in-person visit for the requirement and that they would allow people like nurse practitioners to prescribe it. And as a result, 4 pro-life medical associations and several individual doctors moved for a preliminary injunction that would require the FDA to rescind the approval of the drug, to rescind their 2016 and 2021 regulatory actions. The drug maker intervened to defend the FDA's action. The district court agreed with the plaintiffs and in effect enjoined the FDA's approval of that drug, thereby ordering that drug off the market. And I'm saying that drug because I can't pronounce that drug. Anyway, FDA and Danco appealed and moved to stay the district court's order, and the Supreme Court did stay that order. On the merits, the Fifth Circuit said that the plaintiffs had standing. The Fifth Circuit concluded that the plaintiffs were unlikely to succeed in their challenge to the FDA's 2000 and 2019 drug approvals, but they were likely to succeed in showing that the FDA's 2016 and 2021 actions were unlawful. The court granted certiorari with respect to the 2016 and 2021 actions. And here is what the court determined. The plaintiffs lacked standing to challenge the FDA's actions regarding the regulation of that drug. Article 3 standing is a bedrock constitutional requirement that this court has applied to all manner of important disputes. To obtain judicial determinations of what governing law is, a plaintiff has to have a personal stake in the dispute. To establish standing, a plaintiff must demonstrate that she has suffered or will be likely to suffer an injury in fact, that the injury likely was caused or will be caused by the defendant, and that the injury would likely be redressed by the requested judicial relief. And that's bedrock constitutional law for about the last 150 years. So plaintiffs are pro-life, oppose elective abortion, and have sincere legal, moral, ideological, and policy objections to the drug being prescribed and used by others. Because plaintiffs do not prescribe or use the drug, they are unregulated parties who seek to challenge the FDA's regulation of others. Plaintiffs advance several different causation theories to connect those actions. None of the theories suffices. Plaintiffs first contend the FDA's relaxed regulation of the drug may cause downstream conscience injuries to individual doctors. Now, a conscience injury is somebody used that drug, an infant died, I'm responsible, and there's a good chance that a doctor who prescribes this might come in contact with the person that he prescribed it to later on, and, essentially come to realize that he made a mistake and it might bother his conscience. The plaintiffs, however, have not identified any instances where a doctor was required, notwithstanding conscience objections, to perform an abortion or to provide other abortion-related treatment that violated the doctor's conscience since the drug's 2000 approval. There is thus a break in the chain of causation between the FDA's relaxed regulation and any asserted conscience injuries. In other words, you can't trace a conscience injury that may or may not occur in the future back to the approval of this drug. There would have to be a number of things that would occur. They'd all have to fall in line, and basically it's just too speculative. Plaintiffs assert they have standing because the FDA's relaxed regulation may cause downstream economic injuries to the doctors. And the court says, hey, wait, the causal link between the FDA's regulatory action and those injuries is too speculative, lacks support in the record, and is otherwise too attenuated to establish standing. Moreover, the law has never permitted doctors to challenge the government's loosening of general public safety requirements simply because more individuals might then show up at emergency rooms or in doctors' offices with follow-on injuries. Citizens and doctors who object to what the law allows others to do may always take their concerns to the executive and legislative branches and seek greater regulatory and legislative restrictions. Plaintiff medical associations assert their own organizational standing. Now, organizational standing is essentially an organization saying, we represent people who will be hurt by this, and as a result, we're asserting the organization's right as a representative of all these people to claim standing and advance our arguments. According to the medical associations, the FDA has impaired their ability to provide services and achieve their organizational missions. The medical associations claim to have standing based on their incurring costs to oppose the FDA's actions. Well, now think about that. They have standing because they opposed it. I thought standing had to occur before you could oppose it. See, it's not really a very good argument to say, well, I incurred these costs in opposing your regulation, and the reason I did that is because I opposed your regulation. It's dumb. Contrary to what the medical associations contend, the court's decision in Havens Realty does not stand for the expansive theory that standing exists when an organization diverts its resources in response to a defendant's actions. Havens was an unusual case, and this court has been careful not to extend Havens beyond its original context. So too here. The assumption that if these plaintiffs lack standing to sue, no one would have standing is not a reason to find standing. Rather, some issues may be left to the political and democratic processes. And I would say some issues must be left to the political and democratic processes. So here's what the Supreme Court is saying. The FDA, they approved this drug. They did it pursuant to the same procedure they've used for scores of years. And as a result of that, you have this approved drug. Now, if you don't like that, your remedy is not to come to us and say, deny the approval retrospectively. Your remedy is to go to Congress and the president and say, we want you to fix this problem. And that's what the democratic process is for. I have a personal belief that this is a great opinion on standing. I don't necessarily like the whole idea that it makes it easier for someone to terminate their pregnancy, again, because I believe in life. In my prior work as a respiratory therapist, I held babies in my hand that were the head lay here and the feet came to there. I mean, no more than a foot long. Little tiny infants that I had the job of trying to breathe for and save. And we did a really marvelous job back in the 1980s of getting that done. I imagine they continue to work on that today. The bottom line is I believe all life is sacred, and one of the reasons I don't support the death penalty. This is one of those situations, I think, where the court made the right decision And it made the decision on the basis of the law, not on the basis of some social or perceived social pressure to advance abortion. I think it made the right call. It's essentially a standing-only opinion. It deals specifically with the nature of standing, and it will be cited in the months and years to come on the issue of standing. The fact that it provides relief for the people who make the drug, and the fact that there will be pregnancies terminated as a result, is in my way of thinking, it's regrettable, but I make no apologies for believing as I do. Those are my sincerely held moral, philosophical, and religious beliefs, and you're free to disagree with them. I just ask that you disagree respectfully if you do. I think a lot of times people confuse hard questions with easy questions. This case was an easy question. If the government makes a regulation that is applicable only to the Mazda Miata, and you don't own a Mazda Miata, but someday you think you might want to own a Mazda Miata, you don't get to challenge the regulation. You only get to challenge the regulation if it directly impacts you, not some speculative maybe sometime in the future it might regulate you. So in that regard, this was a pretty easy question from that standpoint only. And that's essentially what these guys were trying to do. They were trying to assert control over something that did not personally impact them. And all of their arguments were attenuated and, in my opinion, somewhat silly. So, for what it's worth, that's the opinion, and I think it's a good opinion. If you have any questions, feel free to drop them in the comments down below. Like, share, subscribe, all that stuff we ask you to do. If you have the opportunity today, go out of your way, do something nice for somebody, and then come on back down here tomorrow, catch me at the beach, and we'll have something else to talk about. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.